All right, good morning. We're back on the record outside the presence of the jury in the case of the state of Iowa versus Luke Truesdell. All of the attorneys are present as well as the defendants. After our discussion about the jury instructions outside the presence of the jury, I went back and printed another draft copy, submitted that to attorneys for both sides. It's like we've got 47 total instructions. There's not a lot, but there is enough evidence to create a jury question on involuntary manslaughter based on the defendant's statements in his interview. It is reversible error to deny him a requested appropriate instruction. So on that basis, I admitted it. Let me know if you see any other issues or you have any other concerns with this printed version. It's helpful for everyone to just go over it one more time and make sure there isn't something that I missed. I did go ahead and include the weapon instruction, so that should be in there. Anything right off the bat that you notice or that seems like it could be a problem from the state's end?
Not that I noticed by the state law.
All right, don't hesitate to let me know if something comes up. What about you, Mr. McCollum? Did you see anything?
Not that I caught, Your Honor. I do want to briefly address, for the purposes of the record, why I withdrew my objection to the dangerous weapon inference. While we were on break, the state provided a couple of cases that the state believed were on point, specifically State v. Ortiz, 789 Northwest 2nd, 761. In reading State v. Ortiz, I believe the case law is directly on point, and my objection, while I don't disagree with what I said, I don't believe the Court of Appeals or the Supreme Court agrees with my interpretation, and because of that, Your Honor, we are withdrawing our objection at this time.
All right, yes, thank you so much. And Mr. Scheer, thank you for the cases. I did want to just make a quick record. It was my plan to run through the jury instructions without Sarah having to report on that. Does that sound okay with everyone?
Yes, Your Honor.
Yes, Judge.
Okay, great. And then was there anything else that we need to take up outside the presence of the jury?
No, Your Honor.
No, Judge.
Okay. I did hear that we were going to make a copy of the instructions for all of the jurors, so we'll go ahead and do that, no problem. And I will let Alyssa know to bring the jury in. Does everyone have the technology set up for their closing arguments?
I believe so.
Okay, if it doesn't work, we can just take a break. Just let me know, it's no problem. welcome back. We are here in the presence of the jury in the case of the state of Iowa versus Luke Truesdell. All the attorneys are also present as well as the defendant. Yesterday, the state of Iowa rested their case in chief, and we had some time to deal with some matters that didn't involve you. So we are now going to proceed with the rest of the case. Hopefully it will be submitted to you by the end of the day for deliberation. Mr. McMullen, is there any evidence on behalf of the defendant?
No, Your Honor. Defense rests.
All right. Thank you. All right. Now is the time to read some of the closing arguments. Some of the jury instructions to you prior to closing arguments from the parties. So I'm not going to read all of them now, but I'll read a portion of them now and then a portion of them to you after the closing arguments. You'll also be receiving copies of these in the jury room. So this won't be the only time that you will hear regarding the law. So I may be reading these relatively quickly, but you will have an opportunity to review them at your own pace in the jury room. All right, so at this time I'm going to release Sarah from reporting. Is there any objection from the state?
There's none.
All right, and any objection from the defense?
No, Your Honor.
All right, members of the jury, the state of Iowa in this case accuses the defendant, Luke Truesdell, of 4 counts of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.2, subsection 1A. To these charges, the defendant has entered pleas of not guilty. Upon the issues, you are instructed as follows. The trial information charges the defendant, Luke Truesdell, with 4 counts of murder in the first degree. Murder in the first degree includes the lesser and included offenses of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. The trial information is the document that formally charges the defendant with a crime. It is merely the method by which the defendant is brought into court for trial. It is not evidence. Luke Truesdell has entered a plea of not guilty. Pleas of not guilty are complete denials of the charges and place the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you that the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Luke Truesdell is presumed innocent and not guilty. This presumption of innocence requires you to put aside suspicion which might arise from the arrest charge or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. You must determine the defendant's guilt or innocence from the evidence in the law and these instructions. You must consider all the instructions together. No one instruction includes all of the applicable law. You shall base your verdict upon only the evidence in these instructions. Evidence is testimony in person or by deposition. Exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to, which were not offered and received into evidence, are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and rulings on objections, any testimony I told you to disregard, or anything you saw or heard about this case outside the courtroom. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. In considering the evidence, please make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe. 2. Whether witness has made inconsistent statements. 3. The witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4. The witness's interest in the trial, motive, candor, bias, and prejudice. The burden is on the state to prove Luke Truesdell guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in a case or from the lack or failure of evidence produced by the state. If after a full and fair consideration of all the evidence you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if after a full and fair consideration of all the evidence in the case or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. When two or more alternative theories are presented, or when two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all of the other evidence in the case. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence. The state has charged the defendant with murder in the first degree. The state must prove all of the following elements as set forth below. On or about June 5th of 2024, the defendant killed Kiana Victoria Ryan by hitting her with a black pipe. Ms. Ryan died as a result of being struck by the black pipe. The defendant acted with malice aforethought. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Kiana Victoria Ryan. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree, as explained in Instruction 25. Malice is a state of mind which leads one to intentionally do a wrongful act, to the injury of another, or in disregard of the rights of another, out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do an injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that will make the person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider or to contemplate or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time before the act. Specific intent means not only being aware of being aware of doing an act and doing it voluntarily, but in addition doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when the act was done. It is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may but are not required to conclude a person intends the natural results of their acts. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that the person knows the act is against the law, it is necessary that the person was aware they were doing the act and did it voluntarily and not by mistake or accident. You may but are not required to conclude a person intends the natural result of their acts. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. If a person has the opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. The defendant cannot be convicted by confession alone. There must be other evidence the defendant committed the crime. In determining the weight and believability of the confession, you should consider the defendant's mental capacity and intelligence, defendant's mental and emotional state at the time it was made, whether it was knowingly and intelligently made, whether the defendant understood it, and any other evidence relating to the confession. In this case, the defendant has decided not to testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains on the state to prove the guilt of the defendant. The state must prove all the following elements of the lesser and included offense of murder in the second degree, as set forth below. On or about June 5th of 2024, the defendant killed Kiana Victoria Ryan by hitting her with a black pipe. Ms. Ryan died as a result of being struck by the black pipe. The defendant acted with malice aforethought. If the state has proved all the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter, as explained in Instruction 27. Murder in the second degree does not require specific intent to kill another person. The state must prove all of the following elements of the lesser and included offense of voluntary manslaughter as set forth below. On or about June 5th of 2025, the defendant killed Kiana Victoria Ryan by hitting her with a black pipe. Ms. Ryan died as a result of being struck by the black pipe. When the defendant struck Ms. Ryan with the black pipe, it was done by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you would then consider the charge of involuntary manslaughter explained in Instruction 29. Considering element 3 of Instruction 27, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however, abusive or insulting, cannot be serious provocation. The state must prove all the following elements of the lesser included offense of involuntary manslaughter as set forth below. On or about June 5th of 2024, the defendant recklessly committed the crime of assault. When the defendant committed the crime, he unintentionally caused the death of Kiana Victoria Ryan. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter. An assault is committed when a person does an act which is meant to cause pain or injury, result in physical contact, which would be insulting or offensive, place another in fear of immediate physical contact, which would be painful, injurious, insulting, or offensive to another person, when coupled with the apparent ability to do the act, or a person intentionally points a firearm toward another, or intentionally displays a dangerous weapon in a threatening manner toward another. The state has charged the defendant with murder in the first degree. The state must prove all of the following elements as set forth below. On or about June 5th of 2024, the defendant killed Ramondas Lamar Cooper by hitting him with a black pipe. Mr. Cooper died as a result of being struck by the pipe. The defendant acted with malice before thought. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you can then consider the charge of murder in the second degree, as explained in Instruction 32. The state must prove all the following elements of the lesser and included offense of murder in the second degree as set forth below. On or about June 5th of 2024, the defendant killed Ramondas Lamar Cooper by hitting him with a black pipe. Mr. Cooper died as a result of being struck by the pipe. The defendant acted with malice before thought. If the state has proved all the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you would then consider the charge of voluntary manslaughter as explained in Instruction 33. The state must prove all the following elements of the lesser included offense of voluntary manslaughter as set forth below. On or about June 5th of 2025, the defendant killed Ramondas Lamar Cooper by hitting him with a black pipe. Mr. Cooper died as a result of being struck by that pipe. When the defendant struck Mr. Cooper with the pipe, it was done by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you would then consider the charge of involuntary manslaughter explained in Instruction 34. The state must prove all of the following elements of the lesser included offense of involuntary manslaughter as set forth below. On or about June 5th of 2024, the defendant recklessly committed the crime of assault. When the defendant committed the crime, he unintentionally caused the death of Ramondas Lamar Cooper. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter. The state has charged the defendant with murder in the first degree. The state must prove all of the following elements as set forth below. On or about June 5th of 2024, the defendant killed Amanda Sue Parker by hitting her with a black pipe. Ms. Parker died as a result of being struck by the pipe. The defendant acted with malice aforethought. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one element, the defendant is not guilty of murder in the first degree, and you would then consider the charge of murder in the second degree as explained in Instruction 36. The state must prove all of the following elements of the lesser included offense of murder in the second degree as set forth below. On or about June 5th, the defendant killed Amanda Sue Parker by hitting her with a black pipe. Ms. Parker died as a result of being struck by that pipe. The defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will consider the charge of voluntary manslaughter, as explained in Instruction 37. The state must prove all of the following elements of the lesser included offense of voluntary manslaughter as set forth below. On or about June 5th of 2025, the defendant killed Amanda Sue Parker by hitting her with a black pipe. Ms. Parker died as a result of being struck by the black pipe. When the defendant struck Ms. Parker with the black pipe, it was done by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you would then consider the charge of involuntary manslaughter, explained in instruction 38. The state must prove all the following elements of the lesser included offense of involuntary manslaughter, as set forth below. On or about June 5th of 2024, the defendant recklessly committed the crime of assault. When the defendant committed the crime, he unintentionally caused the death of Amanda Sue Harper. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter. The state has charged the defendant with murder in the first degree. The state must prove all of the following elements as set forth below. On or about June 5th of 2024, the defendant killed Brent Anthony Brown by hitting him with a black pipe. Mr. Brown died as a result of being struck by the pipe. The defendant acted with malice aforethought. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree as explained in instruction 40. The state must prove all the following elements of the lesser included offense of murder in the second degree as set forth below. On or about June 5th of 2024, the defendant killed Brent Anthony Brown by hitting him with a black pipe. Mr. Brown died as a result of being struck by that pipe. The defendant acted with malice aforethought. If the state has proved all the elements, the defendant is guilty of murder in the second degree. If the state failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you would consider the charge of voluntary manslaughter as explained in instruction 41. The state must prove all the following elements of the lesser included offense of voluntary manslaughter as set forth below. On or about June 5th of 20, I believe it says 25, but it should be June 5th of 2024, the defendant killed Brent Anthony Brown by hitting him with a black pipe. Mr. Brown died as a result of being struck by the black pipe. When the defendant struck Mr. Brown with the black pipe, it was done by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will consider the charge of involuntary manslaughter explained in instruction 42. The state must prove all the following elements of the lesser included offense of involuntary manslaughter as set forth below. On or about June 5th of 2024, the defendant recklessly committed the crime of assault. When the defendant committed the crime, he unintentionally caused the death of Brent Anthony Brown. If the state proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter. During the trial, we're going to reserve some of the final jury instructions for after closing arguments. Attorneys will go ahead and make that change for the date on instruction number 41, count 4. And you can replace those pages with June 5th, 2024. Any objection or issue with that? We have the state.
No, Your Honor.
Okay, Mr. McClellan.
No, Your Honor.
Any additional changes or anything else we need to fix?
The only thing that I noticed in the instructions, Your Honor, which I apologize that we didn't catch this earlier, I don't necessarily believe it needs to be changed, but in the sentence for the lesser included offenses, it just says lesser and include offense, so.
I saw that too. Any objection to leaving it like that, Mr. McClellan?
No.
All right, so we'll go ahead and change the date on instruction 41. That's going to reflect June 5th of 2024. to present their closing arguments. Counsel for the state will have the first opportunity to argue to you. Counsel for the defendant will then have an opportunity to reply and will only address you once. Counsel for the state will then have an opportunity to rebut the argument of the defense. The attorneys will be summarizing the testimony that you have heard and the evidence which has been presented during this trial. They will be recalling the evidence as you will later. They will not intentionally try to mislead you, and if their recollection of the testimony is not the same as yours, please follow and rely on your own recollection. The closing arguments of counsel are merely that, arguments. They are not evidence, nor should they be construed by you as evidence or instructions on the law. The arguments are intended to help you in understanding the contentions of each side. You should give them your close attention. Is the attorney for the state ready to deliver a closing argument?
Yes, Your Honor.
Thank you. Please proceed.
Your Honor, I apologize, not only to Ms. Slaughter, but also to the court and to the jury. May I have a very quick 2-minute restroom break?
Yes, let's actually take 5, and if you do leave, you're welcome to stay here. If you do leave, just remember your admonition, and Alyssa will direct you. We'll meet back here in 5 minutes. Please feel free to remain seated. Thank you. deliver their closing argument?
I am.
Please do so.
Can I have the screen, Judge?
Sure.
I won't leave the lights off. Mass murder in Maryland. Ramondis Hooper. Amanda Parker. Kiana Ryan. And Brent Brown. Ambushed, bludgeoned, and left bleeding on a concrete floor in Lon Brown's outbuilding. There's blood, just a lot of blood. That's what Matt Brown told 911 dispatchers when he arrived at his father's property after being summoned there. Initially believed to be carbon monoxide poisoning, but as soon as first responders arrived, they knew that wasn't the case. Trooper Fairbanks said it best. Carbon monoxide does not cause your face to collapse. Cause of death, blunt force trauma. Lacerated, abraded contusions, hemorrhaging, skull fractures. These are the types of injuries that our medical examiner described most commonly seen in high velocity, high impact vehicle collisions. But for Roe and Amanda and Kiana and Brent, there was no vehicle. There was only Luke Truesdell and a metal pipe. What the evidence showed you in this case, ladies and gentlemen, is that on June 5th, Lon Brown was at home at 3699 East Otter Road in Marion, Iowa, which is in Linn County. That he was just finishing up his lunch when the defendant pulled into his driveway, parked out in front of his house, and got out of that vehicle with his dad, Larry Truesdell. Brent and Kiana were home that day too. Brent and Kiana were planting flowers, trying to improve the landscaping, enjoying a nice sunny but windy June day. Roe went to pick up Amanda from work. You see them later arrive on that green motorcycle, where they also interacted with Brent and Kiana when they were outside, where eventually the defendant met them in that front yard area. And that surveillance video captured their last few moments. We push play for me. Roe and Amanda are walking towards the entrance of that outbuilding. Larry and Luke also enter the screen. As Lon told you, Luke was sent out to check out that inboard motor on that boat. He wanted him to part it and get that boat out of there. And that's exactly where Larry headed. Luke followed the same path into that outbuilding that Ramondis Cooper and Amanda Parker went. That's the last time that anybody saw Ramondis Cooper alive. Amanda came back out. Drink in hand, stopped to talk to Brent, talked to Kiana, went back in that outbuilding. Never to be seen alive again. But that's not the last time that we hear Amanda. And I know the acoustics in this courtroom are terrible, and there's a balance between using the overhead speakers and using a sound bar. But I submit to you, ladies and gentlemen, that when you take this evidence back into the deliberations room, you'll be able to hear it better. And you're going to be able to hear that break. That break in the wind, and hear Amanda scream. Hours, 23:41, I believe, is the timestamp that I want you to listen to in that exhibit. Or just for that brief moment, that wind breaks and you hear it. Brent and Kiana heard it, stopped them in their tracks, and they went to check it out. And as they're going into that outbuilding, Luke Truesdell comes out, does an about face, and follows them in. It's the last time you see them alive. Brent was holding on and fighting for his life when first responders arrived, but as far as meaningful life, that's it. Now, this is zoomed in on this area. And it's grainy. But what you're going to see in this video clip is Luke Truesdell's head come to this back area where he meets up with his father. There it is. And he stays out there. Stays out there for a minute, minute and a half, telling his dad what happened. And Larry goes to check it out. You're going to see another head, Larry, come back towards the outbuilding, and then you're going to see Luke Truesdell, the defendant, appear between that SUV and that van. There's Luke. And there goes Larry. Lots of surveillance video footage in this case, ladies and gentlemen. After Luke and Larry leave that outbuilding, you're going to see on the video that they come to the house. Larry goes in first, Luke right behind him. Larry comes right back out and heads back up to that outbuilding. But then he comes back. He comes back down to the house. And again, I encourage you to listen to the evidence when you get back there, because you're just not going to get a clear picture of what is said on these videos in this courtroom. State's Exhibit 6.3. State's Exhibit 6.3 is a screen record of the surveillance system. And you got the two different camera angles at the same time, and the officer was manipulating the mouse and toggling back and forth between video, and you see an actual time bar running across the bottom of the screen. That's where you're going to find this video. 1 hour, 41 minutes, and 40 seconds into that video is this scene. And when I say 1 hour, 41 minutes, and 40 seconds, that's the not actual time in the video, but the amount of time that's elapsed for that exhibit. You're going to hear Larry. When he runs in that door, the first thing out of his mouth is, "Call the ambulance right now." You hear somebody say, "I don't know"? You hear "Jesus fuck"? Call an ambulance. Call an ambulance. And then you hear Larry say, "What do you mean you don't know?" Lon Brown described that interaction. He described Larry being in Luke's face, that he was 1.5 inches from him. He can't recall what he heard, but he described Larry coming in there in a panic, telling him to call 911, call an ambulance, get him out here now. And how did he describe the defendant? In a daze, mumbling to himself, not making eye contact, kind of incoherent, while Larry's doing damage control for his son. Luke Truesdell told the detectives, Payne and Egley, I came out here. Lon asked me to go check on Brent because he wasn't answering his phone. Okay. I walked out, opened the door. Well, which door did you open? The swinging door. The walk-through door? Yep. On this side? No, in the center. In the middle there? Yes. Okay. Defendant says, I seen a body laying there, and I turned around and walked out. Detective Payne says, did you go? You didn't go in or anything like that? The defendant just shakes his head. Yeah. You went in and what? What happened? Tell me about it. I hit them each. You hit each of them? Well, what did you say that you hit them. What did you hit them with? Right inside the door on the right is a metal bar. We saw that metal bar. And we saw photos of where that metal bar was located. Right inside that swinging entry door on the right, where Luke Truesdell told the investigators that they would find it. That outbuilding is huge. You get some perspective on how big it is between the body cams of officers going in and the Faro scan that we presented you. Huge and full. And that one black metal pipe sitting right there could have been overlooked. Especially because at the onset, the investigators still weren't sure what caused the injuries. They didn't know what they were looking for. But fortunately, the defendant told him right where his murder weapon was. Right inside that right door. Right there. 42 inches. 42 inches. That pipe. That. I encourage you, when you go back to deliberate, even if you choose not to touch the pipe itself, lift that box. See how heavy that metal pipe is. And then ask yourselves, is that a dangerous weapon? What did we find out about the pipe? We found out that on the pipe there was DNA. And whose DNA did we find? We found different types of DNA. We found blood evidence belonging to Ramondis Cooper and Kiana Ryan. We found other DNA that was considered to be a minor contributor to the spots that the criminalist decided to swab that were unidentifiable because there were not enough points or loci within that DNA to confirm whom it belonged to. But I don't think anybody is doubting that that is the same pipe that struck all 4 victims, considering that the paint from the end of that pipe is embedded in each one of their skulls. The criminalist sat up here and explained to you, ladies and gentlemen, why she makes the decisions that she makes and how she is familiar enough with blood evidence to be able to look at stains and make an educated and an expert guess as to which stains are going to provide the cleanest samples. That if she tested every spot, that the testing would go on infinitely, and that's not how she does her job. Blood evidence. Ramondis Cooper, Kiana Ryan. You know who else's DNA was on that pipe? The defendant's. And the defendant's DNA wasn't in a random place on that pipe. It wasn't somehow mixed in with the blood. It wasn't a random hair. The criminalist explained to you that one end of that 42-inch long pipe was bloody. You see it. And that the other end did not appear to have any blood on it. But what she did, and you can see it when you examine this pipe, is she found a rough surface, a spot where she thought it would create the most friction from somebody's hand. Because to get touch DNA and to get skin cells, it's easier to get them from a place in which it's friction and rubs off. And she swabbed that area. And in that area, on the non-bloody end of the pipe, where someone would hold the pipe to swing it as a weapon, she found the defendant's DNA. And then the hair. Kiana's hair. 40-some strands of hair, 37 didn't have roots. She tested the root and the shaft, and her conclusion after doing DNA analysis on the hair that was on that pipe is that the hair belongs to Kiana Ryan. Now, officers continue to speak with the defendant when they transported him to the Linn County Sheriff's Office for additional investigatory work. And in that car, y'all heard it, he says that he's been up for 2 days, hasn't slept in 2 days, that he's been smoking methamphetamine. 2 days awake, some sort of a meth-induced bender. He's got a lot to talk about. He talks about his past and his grandmother and how he got strung out again after his grandma died and how things are real hard on him and people stole money from him and people tried to run him off a bike 6-7 months ago. It just goes on and on, this ramble. But there are definite points of clarity in that ramble that the defendant went on. The defendant talks about how he loves his babies and they're going to hate him forever after this. How they, being the folks out on Otter Road, were sex trafficking women through a drug ring, that his killing those people, maybe drugs were a factor. It's got to do with a lot. He needs help. And that he wanted to take them all down. The other things he said while he was in that car, when there was some conversation about whether or not Luke gets his methamphetamine from Roe. I don't know his name. I don't know his real name. I just know what they call him. well, the black guy that you hit. Oh, yeah. Him. The black guy that I hit with a metal pole and left laying there bleeding, dead. When asked if Amanda said anything as he chased her back in that corner where he got her stuck between that sawhorse and that wall, did Amanda say anything? Well, what'd she say? No, no, no. No, no, no. No, no, no. No, 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 as you have just brutally beaten and bludgeoned her boyfriend and have chased her into a corner where she can't escape and gets wedged, and her herself is then beaten and bludgeoned to death. No, no, no. Ladies and gentlemen, in these instructions that Judge Dupuy just read to you, you're going to get what we call marshalling instructions, and it's going to be a lot clearer when you can see it in front of you. It's broken down by count, okay? Each count has a different victim, and each count has what are those called lesser included offenses, where you get to consider first, murder in the first degree, murder in the second degree, voluntary manslaughter, involuntary manslaughter, for each victim, each count. And they are labeled well, so it should be easy to navigate through them once you can see them. But the elements for murder in the first degree don't change per victim. The only thing that changes is the name associated with it. So for the state to prove the crime of first degree murder, we have to first prove that on June 5th, 2024, the defendant hit the victims, insert name, with a metal pipe. And I submit to you, ladies and gentlemen, that when you go back and review the evidence and review your notes and deliberate together, that there is no explanation that is reasonable other than Luke Truesdell beat and bludgeoned those 4 people to death with a metal pipe. The metal pipe that he directed investigators to, that hit each of them, that he admitted. That the victims died as a result of being hit with a metal pipe. Those autopsy photos were tough. And Dr. Diol did a good job of explaining how to correlate certain injuries to the documented evidence of injury in his report. You saw it. There is no question that the pipe that hit them repeatedly in the head was their cause of death. That the defendant acted with malice aforethought, and that the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill the victims. So what is malice, and what is malice aforethought? Malice is a state of mind. And what you're going to see in the instructions is that it says, a state of mind which leads one to intentionally do a wrongful act to the injury of another, whether that's out of actual hatred or with an evil or unlawful purpose. Wrongful act, striking someone in the head with a metal pipe. You don't strike someone in the head with a metal pipe if you don't have some actual hatred or have an evil, unlawful purpose behind it. Talks about us being able to establish evidence of actual hatred or by proof of deliberate or fixed intent to do injury. I didn't clean my PowerPoint up. It may be found from the acts of conduct that the defendant did and the means used in doing the wrongful and injurious act. It only requires such deliberation that would make a person appreciate and understand the nature of the act and its consequences. This is not an act done in the heat of passion. And what you're going to see in these instructions is that you get an instruction on voluntary manslaughter. Voluntary manslaughter considers that sudden, irresistible passion, that act of rage, that you can't stop it. That type of crime is contemplated for situations where husband walks in, catches his wife sleeping with another man, and kills everybody. That's that heat of passion, that rage where you didn't have time to stop and think and contemplate your actions. This is not a heat of passion crime. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. And you're going to see that. It does not have to exist for any particular length of time throughout the jury instructions. There's this fallacy that malice aforethought and premeditation require some documentation or a journal entry or month-long planning. But that's not what the law requires, ladies and gentlemen, for premeditation. The act of stopping and contemplating is enough. Deciding that you're going to do something, taking the time to go and get a weapon to do it, coming back with the weapon, and then following through with that deliberation, that's all that's required for premeditation, ladies and gentlemen. It does not have to be on a calendar in someone's journal hidden under their bed to establish premeditation. The act of walking out of an outbuilding and realizing the gig is up and Brent and Kiana are going to go in and discover your handiwork. So instead of continuing on, you do an about face, you follow them back in through that same door, you grab that same pole from the area where you left it, and then you beat them to death as well. That, ladies and gentlemen, is premeditation. That was thought, that was planned. Malice aforethought and premeditation, and you'll see it in the instructions, can also be inferred from the defendant's use of a dangerous weapon. That's what the law is. If someone uses a dangerous weapon to commit the crime of murder, you get an inference. You get to infer that the thought in itself to use a dangerous weapon to commit the crime is malice aforethought, is premeditation. You're also going to see in those instructions the terms willful, deliberate, and premeditate. And these are the definitions you're going to get. Willful means an intentional or by fixed design or purpose and not accidental act. Okay? You don't accidentally swing that heavy of a pipe that many times at that many people, and your act could be mistaken for anything other than willful. To deliberate, to weigh in one's mind, to consider, to contemplate, or to reflect. None of us can say what set Luke Truesdell off in that building. But we do know that he did not enter that building carrying that pole. So somewhere in the melee, in the chaos that he created inside of that building, he made a willful and deliberate decision to pick up that pipe and do the atrocities that he did. And then to premeditate. To consider or ponder upon a matter before acting. Willful, deliberate, premeditatedly. There it is. And you're going to see that. It's not just in my PowerPoint. That is the law, ladies and gentlemen. That it need not exist for any particular length of time. The thoughtfulness that he put in to these 4 executions And that's what they were. 4 executions. That's deliberation and premeditation, ladies and gentlemen. In this set of instructions that you're going to get from the court, it also talks about specific intent. Specific intent, arguably, can be one of the more difficult elements to prove. And the reason that specific intent is difficult to prove is because specific intent and proving someone's specific intent requires you as jurors to get inside someone's head and decide what they were thinking at the time that they committed an act. Okay? And because that's a difficult task, the law gives you another inference here, that you can conclude that a person intends the natural results of his acts. So what's that mean? The natural result of the act of swinging that pipe repeatedly and hitting people in the head with that pipe repeatedly is certain death. So when the marshalling instruction says that the state has to prove that the defendant did the act of swinging the pipe with the specific intent to kill the victims, you get to infer that he could not have intended anything other than what resulted, because that's the natural result of that action. And that's what that instruction says, ladies and gentlemen. If a person has the opportunity to deliberate and uses a dangerous weapon against another that results in death, you may, but are not required, to infer that the weapon was used with malice, premeditation, and the specific intent to kill. Malice, premeditation, and the specific intent to kill. You're going to get in your instructions another instruction that I want to bring to your attention that talks about differing theories. Starts out when 2 or more theories of the crime are presented, or where 2 or more facts result in the same result. But it doesn't have to be a unanimous decision on what fact or theory got you there. It just has to be the final verdict that's unanimous. What that means is that there may be facts to juror number 1 that are more important than facts to juror number 7. And that if juror number 1 relies on the fact that's important to them, and juror number 7 relies on a different fact, but those 2 separate facts get you to the same result, that's okay. Theory of the crime, there's not a lot of theories in this case. Theory of the crime is that because the defendant hadn't slept in 2 days, was on a meth bender, and as he said, wanted to get help and get clean and stop some perceived sex trafficking ring that only his mind came up with, that he had to do this, that he had to rid the world of them all, take them all out. And that's what he did. Took them all out. But if in reviewing the facts, one of the jurors comes up with a different theory of this crime, or can contemplate why something this heinous happens that's different from what the defendant's own words said, you get to consider that theory too, and it doesn't matter which theory you rely on as long as the end result or the conclusion is the same. And I submit to you, ladies and gentlemen, that after almost 2 weeks of being in this courtroom, hearing from numerous witnesses, having an opportunity to go back and deliberate and review the evidence that's been presented and talk amongst yourselves, there's only one reasonable and commonsensical conclusion that you can reach in this case. And that's that Luke Truesdell, the defendant, killed Ramondis Cooper. That he killed Amanda Parker, that he killed Kiana Ryan, that he killed Brent Brown, that he is responsible for first-degree murder for those 4 victims. And the defense is going to have an opportunity to stand before you and get their closing argument, and then you're going to hear from me again. And I'm going to ask you at that time, the same way I'm asking you now, to find this defendant guilty of murder in the first degree for each of the victims, for each of the people whose lives were snuffed out by his hands, and to find him guilty of all 4 counts. Thank you.
All right, thank you, Ms. Slaughter. Mr. McMullen, would you like to give a closing argument?
Yes, Your Honor, thank you.
Please proceed.
Ms. Sarah, can you hear me okay? Thank you. May it please the court, counsel, Luke, ladies and gentlemen of the jury. I want to start, folks, by thanking you for your time, for your attention. It has been a long couple of weeks for us, but also, as I can tell, for you guys. You guys have seen some horrendous images. You've heard some horrible theories of what happened. And through it all, you've given us your attention, you've taken notes, and trust me when I tell you, somebody who's done a lot of trials, it's not something we get very often. And so I thank you. Mass murder in Marion. Bludgeoned, left bleeding and dying on a concrete floor. That's what the state started their closing argument with. And it's true. Well, they left out the part while all this was happening, while Larry was taking a cigarette break. 4 people, either dead or dying. Larry's out front, walking back and forth, smoking a cigarette. He's not rendering aid, like it's been alluded to. He's out there, relaxed, pacing back and forth, puffing on a cig. And the state says that Luke was in a daze, and Larry was doing damage control. Or Luke was dumbfounded by what he had just seen, 4 dead bodies. Absolutely in shock by having seen 4 bodies. Larry was trying to minimize what had just happened based on his own actions. And we don't know which is true. Can I have the screen, Your Honor? Folks, we said in our opening argument that all we wanted you to do as members of the jury was to hold the state to their burden. It is the state's obligation to prove this case beyond a reasonable doubt. And you will get a definition of what a reasonable doubt is, but we are reiterating that that is all we are asking for you to do today. Don't jump to the same conclusions that they jumped to. Don't make the assumptions that Egley made unless you yourself believe those. Think for yourself. Don't get caught up in the pageantry and the emotion of what happened. Don't think to yourself, there are 4 dead bodies. Somebody has to be held accountable. The person who's sitting right here, Luke Truesdell, is sitting there. He must be held accountable. No. Hold him accountable if the state has done their job. If the state has proven their case beyond a reasonable doubt, then you hold them accountable. But if they don't, either through a lack of evidence or the police not doing a sufficient job, and you have holes in your thought process. That is reasonable doubt. There are 5 questions that we hammered on during our cross-examination. I'm sure all of you picked up on what our point was. The first one was it really a confession? Oh, excuse me, I'm going to back up for a second. The way the state gets past their burden is by using tunnel vision and confirmation bias. We'll talk about that quite a bit. But as you're listening to the statements made by Luke in his interviews, Lieutenant Egley hears what he wants to hear. Luke makes a lot of statements. He says a lot of things. A lot of it doesn't make sense. And intertwined in there, interspersed in there, are random comments that Lieutenant Egley just jumps on and holds them as fact, holds them as absolute truth. The images that you see on the surveillance footage, those 2 shadows, you can't see who they are. And we'll show you a slide here in a couple minutes, but you can see on the overhead view that there is a whole section of the yard that is not at all covered by surveillance footage. You cannot tell who's there. You cannot tell where Luke is. You cannot tell where Larry is. You cannot tell when Larry got to the boat because it's behind that van, and you cannot tell if he stays there. Similarly, you cannot tell if Luke is in front of the shed, if he's in the shed, if he's over by the trees, if he's over by the camper, if he's over by the van. And why not? Because it's not on surveillance. You cannot tell. Don't jump to the same conclusions that Lieutenant Egley does. Before we get to diving into that, though, we're going to talk about whether it was really a confession. Now, you'll get this jury instruction, but the jury instruction requires you to evaluate the defendant's mental or emotional state at the time it was made and any other evidence related to the confession. I am begging you, when you go back to deliberate, listen to the state's exhibits 6.1 and 6.2. Those are the 2 exhibits that have Luke's statements on there. I was listening to them again last night, and I have over a page, with the statements that are taken out of context. They were utilized like a sword in this trial. And please, listen to them. I'm going to read to you some of them as an example. When Luke was originally asked what happened, his response was, "I don't know." He tells Sergeant Payne, "I opened the center door, saw a body, and walked right out." Sergeant Payne asks him, "Did you go in?" Luke shakes his head no. He shakes his head no. "I never went inside." And then Sergeant Payne tells him, "So you went inside." A man who is high on methamphetamines and has just seen 4 dead bodies tries to tell him what he knows by shaking his head no, and then is convinced, "Yeah, you did. You went inside." And Luke just goes along with it. And it continues. He gets asked, "Did they do something to you?" "I don't know. I really don't know." Luke says they were arguing and stuff. One was laying there. Brent was still kind of breathing. So in the first confession alone, and I'm sorry, I'm putting confession in quotes here because you guys determine if that's a true confession. The state has labeled it as one, but you guys get to determine if that's actually confession. But in the first set of statements alone, Luke denies being in the building at all. He says, I saw bodies and I walked right out. Then he gets told that he went in, and he just goes with it. And then when he says that he was in there, he doesn't admit to having done anything. He describes a crime scene. Folks, this is not me trying to convince you that this is what happened. This is actually on the audio. This is actually part of Luke's statements. In the second interview, and this is brought up by Lieutenant Egley, Luke says, quoting here, that he feels so fucking amazing. And the state wants you to believe that that is because he has just released this pressure of having just committed 4 murders. That is how he feels. He has this pressure lifted off of his shoulders. But if you listen to the audio directly prior to that, Luke is talking about his grandma. He's talking about how he's opening up to childhood trauma that he's never talked about to anybody, or at a minimum in years. He's vocalizing some of the awful, awful things that he has seen and been through in his life. He is not saying that he feels better admitting to having killed 4 people. And the problem with that is Lieutenant Egley clearly knows. He said it on the stand. And you folks will have the DCI results. Lieutenant Egley knows that Luke is high on methamphetamine. He knows that at a minimum, he just saw 4 dead bodies. And yet, he chose that time, that instance, to push him for real information. Didn't wait for him to sober up so he could be a little more clear-headed. He chose that time. I just want you to listen to those statements, guys. That's it. Okay? If you hear them the same way that the state hears them, well, I can't argue that. But if you hear them for what they are, if you hear them the way that we hear them, you will understand that these are not confessions. These are statements made by somebody who is clearly traumatized, not only from what he had just seen, but also from the life he's been forced to live, and is high on methamphetamine. And you'll hear that they are not confessions. Second big problem. Does Luke actually go into the shed? From a physical standpoint, from a very obvious standpoint, I don't know. You guys don't either. You can't see it. Now, the state argues that, gosh, we found DNA on that pipe. There was a spot of blood on Luke's shirt from Ramondus Cooper. He had to have been in there. Well, there's some problems with that. We're going to talk about it. Lieutenant Egley acknowledges that you cannot see everything going on behind those vehicles in the yard. You can't. None of us have X-ray vision. We're not Superman up in here. You cannot possibly tell what's actually happening behind 3 large vehicles. So it is entirely possible that somebody's walking around back there and you just can't tell. Similarly, there's a line of trees. And again, we'll pull up this image here in just a second, but there's a line of trees. And Lieutenant Egley admitted it is entirely possible that somebody is walking along that line of trees and you can't see them. So the state wants you to believe that because Larry started at the boat, well then gosh, he had to have stayed at the boat. Can't prove that. That's an assumption. That is speculation. The state wants you to believe that since Luke walked towards the shed, he had to have entered the shed. Can't see it. It's entirely possible that Luke walked over to the trailer. Not the trailer, the camper. It's entirely possible that he went over to that other little shed that you can see in the overhead image that he explored. We don't know. You can't see. The question of whether does Luke go into the shed is a huge question because you can't tell. There are two things that suggest by the state that Luke was in the shed. One, there's DNA on that pipe. Fine. Here's the problem with the DNA on the pipe. State's own witness said DNA exists on items for decades. Now, we're not suggesting that Luke touched that pipe decades ago, but Brent Brown told you he had been there 2 weeks prior. Lonnie told you that he had been there just a couple of days prior. And the state cannot suggest to you that maybe he touched the pipe then. Point is, we don't know when the DNA got on the pipe. We don't know. And you can't know. And supporting that is the idea, if you guys go back and watch the surveillance footage, the state suggests that right before Brent and Kiana go back inside the shed, the last time, as they say, you ever see them alive, you see Luke come out, right? Here's what Luke looks like. Luke is strolling along, okay? I'm going to join in the state's request. Grab this pipe, hold it, lift it. Because the state's theory is that Luke had just beat 2 people to death with it. And yet when he comes out, he puts his hands in his pockets, he's not out of breath in the slightest, and he is strolling along. It doesn't make any sense. It doesn't make any sense, and the state can't explain it. That is reasonable doubt. Now, I'm going to talk to you about the blood that they found on Luke's shirt and on the back of Luke's shoes, but if you'll humor me for a moment, I'm going to come back. That's a whole separate slide. So we'll talk about the third thing that the state can answer, and that is what's going on in the shadows. You cannot see, as we've talked about, you cannot see anything from about here this way. Nothing. So when Luke crosses the front, this corner right here, he's gone. The state cannot put him in that shed. The state cannot put him in the camper, in the van, or over here by this other little shed. They can't. Egley talked about how you can walk right through here, underneath these trees, which is right by the backside of this boat, where Larry was. Larry walked out to the boat. We know that. But you can walk from right here to right here, never get seen on camera, and then walk right there without ever being seen on camera. And if the state can't show you, if the state can't prove to you that not only wasn't Luke at the shed, they also can't show you that Larry was constantly or consistently at the boat. They can't. The only thing that you see are 2 black shadows. That is it. Do not jump to the conclusion that that has to be Luke and that has to be Larry, because there's nothing to suggest that. They are 2 black shadows. Good. Technology's fun, folks. Okay. Next thing we're going to talk about. Whose blood is actually on Larry? Can we show those pictures? He's got blood on his hands. Should not put that down. And you see it. You see it in his fingernails. You see it over here on his hands. You see it up here on his hands. You see 3 red spots. Could very easily be blood on his shorts. And you see it up here on his hands. Whose blood is it? We don't know. And why? Those DNA swabs were never submitted. They were never tested. The state wants to confuse you by bringing up words like CODIS. But Egley flat out told you, CODIS checks for DNA that's tested. But we know Larry's DNA is on his own hands. Who else's DNA was on his hands? We don't know. They never tested it. Those 3 spots on Larry's shorts that could very easily be spatter, did they test those? Nope. Didn't test those. His shoes that should have blood on them, if he was in fact helping Brent, should they have blood on them? Sure. Test those. Nope. His shirt. You can see he's shirtless. Surely they checked his shirt, right? No. They threw it out. They didn't fail to test like they did with his hands. They didn't fail to take into custody like his shorts and his shoes to see if they needed to test. No. They threw it out. Along with the towel. Items that could have been critical to determining whether Larry knew more about this. And they didn't test it. They threw it out. And why? Talked about it. Tunnel vision and confirmation bias. They had already made the determination that Luke did this, and instead of finishing their investigation, they said, "Oh, got the right guy. We're all done here. We're done." Now, the state brought in Lonnie. Lonnie's a nice guy. I talked to him a couple times, and I'm not trying to say anything negative about the man. He's a very nice guy. But the state tried to refute the notion that Larry didn't have blood on him when he came into Lonnie's house, because that's what Lonnie told you. Okay? The problem with believing that, or the problem with putting a lot of faith into that, is Lonnie couldn't even remember who came into his house first. Lonnie admitted straight up, "It's been so long ago, I don't really remember what happened." So his statement that Larry didn't have blood on him, how can you believe that? How can you put too much faith in it? And again, when you watch all the surveillance footage after Matt has been called, you see Lonnie outside, but he was supposed to have been rendering aid. He's outside smoking a cigarette. He's not offering help. He's smoking a cigarette. Most importantly about these images, and you'll get better images, but we talked a lot about black specks from the ME. You see the black specks? See it? Wouldn't it be nice to know if that was the same? Wouldn't it be nice? Okay. Told you I'd come back to it. Here we are. The $1 million question. Why is there no blood on Luke? And I don't mean no blood. Obviously, there's 2 specks of blood on Luke. But why is there not a whole lot more? You saw the pools of blood. You saw the blood spatter. And you can see it on these images. Blood spatter, blood spatter, blood spatter, 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 spatter. It is everywhere. How does Luke not have any on his hands? At a minimum. Let alone his jeans or his shoes. Not the back of his shoes, because that just doesn't make any sense. But why does he not have blood on the part of the pipe that the state is saying that he held? His hands. And the state made an insinuation early on in the trial that because he was hitting like this, the splatter was all going that way. I can tell you, that's a bad argument. Here's why. We've all been in a pool, right? We have all splashed somebody in a pool. When you splash somebody, not all that splash goes that way, does it? No, some of it ends up back on your face. Undoubtedly and inevitably. We've all walked through a puddle. The puddle doesn't all go the way you're stepping, does it? No. Some of it ends up on your pant leg. We know it, because everybody's done it. So the idea that Luke brutally bludgeoned and beat 4 people to death and somehow has no blood on his hands makes zero sense. So, let's say he washed his hands before they took a picture of him. Where? There's no running water in the shed. The only running water in the yard is a hose, which you would have seen him use. And not a single person testified or told you that when he went inside Lonnie's house, he washed his hands. And most importantly, and I'm going to go back to when Luke comes out and he's strolling around, he sticks his hands in his pockets. Why is there no blood on his jeans? In his pockets. There's no blood on his jeans. How? How does that happen? How, with 4 bodies and that much blood, do you only find 2 specks on Luke? And those specks make zero sense. And here's the problem with them, okay? The one on his left arm, they said it's 4 millimeters. You know how big 4 millimeters is? It's the size of a pencil eraser. It's tiny, okay? And that's a t-shirt. So we've all spilled water on a t-shirt, right? What happens as it dries? It expands. It soaks in, right? And so the blood that actually hit his shirt was not near 4 millimeters. That's a tiny, tiny, tiny little bit that as it soaked in became the size of a pencil eraser. That is not enough blood from beating 4 people to death with a metal pipe. It's just not. And similar, on the back of his shoe, it's 1/4 of an inch. On the back of his shoe. How? Maybe Luke walked into the shed. Maybe he saw what had just happened. Somebody tossed him the pipe, and as he catches it, momentum sends a tiny drop of blood onto his arm, and then as he's carrying it, another drop of blood drops onto the back of his shoe, and he puts it right there by the door. And that's why he knows where it is. It's a possibility. Sure fits the evidence, doesn't it? Four bodies, ladies and gentlemen. There is not a speck of blood on his hands. What? So has the state firmly convinced you of their theories? And I ask you again, don't get caught up. Please Don't get caught up in the emotion of this case. Don't get sold by the state's attempt to rile up your heartfelt emotions. Like the rest of you, we are heartbroken by there being 4 dead bodies. But the question isn't whether we're sad. The question is whether has the state firmly convinced you of their theories. So I go back, was it really a confession? There's 2 ways to look at it. State has told you their theory. I've told you ours. You guys get to decide. You get to decide on if somebody who had just seen 4 dead bodies and is high on methamphetamine, who is talking about the John Wick franchise. He's talking about flashbangs and hand grenades. He's talking about $750,000 being stolen from him. He's talking about his grandma. He's talking about everything. You guys get to decide if what he says about what happened in that shed really happened. Does Luke go into the shed? We don't know. You can't. The state's going to get up here and the state's going to tell you how everything that I said is wrong. And that's fine. But there are some undeniable truths that the state cannot argue with. Luke was high on meth when he talked to the police. Luke had just seen 4 dead bodies. You have to take that into account when you're determining if what he said as it relates to his involvement was actually him saying, I was involved, or if it's him just rambling, like the rest of the 35 minutes. Was he in the shed? You have to decide, can the state put him in the shed? Can the state prove beyond a reasonable doubt that he was? Because there's 2 ways to look at it. One, the state has suggested, of course he was in there. DNA. 4 bodies. Listen to what he said. You can't put him there. There are other very reasonable alternatives for what Luke was doing, rather than hanging out in that shed. He was exploring. He was over by the camper. He was over by the van. Is there a reasonable alternative for what Luke was doing other than being in the shed? Yes. Absolutely. Who's walking in the shadows? State wants you to believe. They say over and over again, Luke and Larry, Luke and Larry, Luke and Larry. You can't see them. You can't. You have to jump to the conclusion that Luke had to have only hung out by the shed, and that Larry had to have only hung out, by the boat, because you can't see otherwise. Folks, the absence of evidence isn't proof. Saying you can't see otherwise doesn't mean that there isn't an otherwise. Reasonable doubt says proof or lack of proof. Saying we don't have proof doesn't mean it's proof. You don't know who's walking in the shadows. It's easy for both Luke and Larry to have walked back and forth underneath that tree line the entire time, and we would never know. Lieutenant Egley admitted it. And if we can't know, we can't just jump to the conclusion, once again, that those 2 shadows you do see are Luke and Larry. Whose blood was on Larry? I can't get over this. You don't know. It was never tested. His hands were never tested. His shorts were never tested. His shoes were never tested. Whose blood was on Larry? I know less than you guys do, and I've been working on this case for who knows how long. But there was somebody else there that day. and the police, using their tunnel vision and their confirmation bias, they just decided, oh, we're done here. And they never looked. It's reasonable doubt at its finest. And why is there no blood on Luke? I gave you guys a reasonable explanation how those 2 spots ended up on Luke. Now it's a guess. Because I don't know, I wasn't in there. But it makes sense, right? It makes perfect sense. Catches right here, momentum, carries the blood there, drops it down here, gravity carries it to his back heel. That would explain how, even though he's beat 4 people to death, there's only 2 tiny spots on him. Right? Don't be fooled, folks. Don't be fooled. Don't get caught up in having to lay the blame on somebody because of the nature of this case. Don't be fooled by Lieutenant Egley getting up there and saying, even though he doesn't know any more than we do, that Luke and Larry did this, Luke and Larry did that, because he doesn't know, just like none of us know. Don't be fooled that Luke made all of these admissions in his statements without listening to the context and everything else that he said. Don't be fooled that Larry's hands shouldn't or didn't need to, because they had Luke and he was the guilty party. Don't be fooled. Demand answers. Think of these 5 things when you're back there deliberating, and think to yourselves and say to yourselves, no, we need to know. Because if you can't resolve these questions, we can't tell if Luke's guilty. And if you can't tell, folks, that's reasonable doubt. And with reasonable doubt, he's not guilty. Folks, I want to thank you again. I do. Can you clear the screen, please, Your Honor? Thank you. I want to thank you one more time. State's going to get a chance to come up here and talk to you one more time, but I do. I appreciate the attention you've given us, the time that you've given us, and I ask you to just keep with it. Keep with it for just a little while longer. And when you look at all the evidence, see that those answers should have been provided. They weren't. And because they weren't, that's reasonable doubt and return a verdict of not guilty. Thank you.
Thank you, Mr. McCollum. Is the state ready? Is the state prepared to give a rebuttal closing? I am. All right, whenever you're ready.
All 14 of you are sitting here for a reason. We did over a day's worth of jury selection. And all of you remained on the jury because there was something that you said or did that conveyed in us you have the common sense that we were looking for. And what you're going to see throughout the instructions is that reoccurring theme where repeatedly you as jurors are told to use your reason and your common sense. It's not a request. It's the law demanding that when you evaluate evidence in this case, that you do so using your reason and common sense. Mr. McMullen stood up here and talked to you about reasonable doubt. And we talked about that a lot in voir dire, and now you've seen the official definition of it about being firmly convinced. But reasonable doubt is more than just mere possibilities. The mere possibility that this defendant didn't kill those 4 people. Theorizing and posturing is not evidence. And to say that the state doesn't have evidence when there's no other evidence refuting that is not reasonable doubt. You don't get to just pull possibilities out of the sky with no evidence to support it, because what you're going to see in those instructions too is my statements and his statements are not evidence. He may give you some things to consider, but the evidence that you have to consider is what's been presented, not mere possibilities, not the drugs in the pocket of the pants that you borrowed and didn't notice the meth there like we talked about in voir dire, not possibilities. He can stand up here and possibility you to death. And frankly, some of the arguments are insulting to your intelligence and your common sense, ladies and gentlemen. He wants you to disregard all of the evidence that's presented and presents the argument as if the entire state's case is based on one specific piece of information and hopes that you are not intelligent enough to look at this case in its totality. If you are not there yourself to see it, is there going to be some doubt? If it is not caught on 4K HD surveillance video for you to view, is there going to be some doubt? I asked you that question in voir dire. Doubt and reasonable doubt are not the same thing. Reasonable doubt has to be such that you are not firmly convinced, that you could not act upon the information that you have, that you are afraid to make a decision because you aren't firmly convinced. Disregard all the evidence. That's what they're hoping. The mere possibility that Luke Truesdell goes around that corner and for no reason takes some covert ninja path through the trees, around the red shed, pops out at the boat. And in doing that, Larry decides to take that same path back through the shadows, around the tree, ducking and diving, and he sneaks into the shed and he massacres these 4 people, and disregard the fact that the surveillance video that you have to watch live streams. It's not motion activated. It's not only picked up when somebody moves. It is going, and you get all of it. And they want you to believe that the head that you see leaving the shed could be Larry's, even though there's absolutely no evidence that Larry ever left that boat. And I say no evidence because you have the evidence. This is not a guess. You have the video to watch. And in the video, Larry goes to the boat, and there are no heads moving until Luke's head leaves the outbuilding. You can look back there, you can watch it from start to finish. There's hours of it for you to review. And you are not going to see a head come from that boat until after the head from the shed goes in that direction. Luke goes out there and tells his dad what he did. And his dad comes around the corner to check it out. Because you know who else comes from that boat? Luke. And again, in that evidence, you're not going to see anywhere where somehow those 2 magically clicked their heels, sprinkled some fairy dust, and switched places. Larry was always at the boat. Luke went in the shed. Somehow, the defense wants you to just disregard that And then to not look at that in conjunction with everything else you said. You know, you could poke all the holes you want in this case, especially if there was just the DNA, if there was just these admissions, if there was just the surveillance, if there was just. But when you put all of that together, common sense demands of you, ladies and gentlemen, to see the whole picture, to see all of the evidence together, not one individual piece, not to rely on a bunch of theoretical possibilities that there's absolutely no evidence to support when there's actually evidence to the contrary. Would we have loved to have a surveillance video in the shed? Absolutely. But we don't. What we do have is a surveillance video that gives you perspective and positioning of all the parties. No, we cannot see someone walk into that building. Can't see Roe and Amanda walk in there. But guess what? They did. And do you know how we know that? Because they died in that outbuilding. Can't see Kiana and Brent walk in that building, but we know that they did. How? Because they died in that building. Can't see Luke Truesdell walk in that building, but we know that he did. How? One, he told us he was in the building. He told us what he saw. He told us he went in there. He told us that he hit each of them. Two, he knows where the murder weapon is. Literally a needle in a haystack. And he directs law enforcement officers directly to it. And he's nowhere else on that video. Luke's head leaves the shed and goes to the boat. There's a bunch of conversation back behind that truck, that junk vehicle out there. Dad comes back. Luke comes between the van. And then he runs into the shed with his dad. Now, I didn't clip all of it and put it in the PowerPoint, but the other thing you get to consider when you review all this evidence is the body language, right? You can't hear everything that's said between Luke and Larry, but what you see is a pissed off father and a son moping behind him, really ashamed and embarrassed of what he did. I don't know what I did, Dad. Just following behind him. And Larry's turning around and he's yelling at him, and he's calling him an idiot, and he's saying the F word, and you can hear him on video. What happened? What'd you do? Lon, call 911. Call an ambulance. But the defense wants you to believe that Larry's our murderer. Larry, who's out there trying to pull a free motor off a boat that he can flip and make some money off of, just stops in the middle of that with absolutely no motive, no means, no relationship, and goes and kills 4 people, magically gets from the boat to the shed. Because that makes sense, right? That lines up with reason and common sense and all of the other evidence in this case. That is absolutely ridiculous, ladies and gentlemen. The video, the admissions or confessions or whatever you're calling them, when did admitting that you hit somebody's, 4 people, when did that not become enough in conjunction with everything else? And then this creative story about how he got blood on him. Absolutely no evidence that in the process of them going back in there together, somebody who's not known chucks this 60-pound pipe. 60, that might be an exaggeration. Feel it for yourself. But this chucks it to him, and in chucking the pipe, that just happened to be how he got that 1 speck of blood on him. And then after he caught the pipe and he's dragging it behind him, then some possibilities, maybes, no evidence of anything like that. You know who else didn't say anything like that happened? The defendant. You know who never said, it wasn't me, it was my dad? The defendant. He didn't blame anybody else. He owned it. And he felt bad about it. And then he told you how he felt good getting it off his chest and how he worried about his kids never forgiving him and going to hate him. No evidence to the contrary, just mere speculation. Apparently, Mr. McMullen is a blood spatter expert and wants to compare being completely soaked from head to toe in a pool, splashing someone, with being 42 inches away from somebody, swinging a pipe. When you see that all of the blood evidence is going in that direction on Roe's body, right? Because that's the blood spatter that they put the pictures of. But he wants you to believe that in going that way, some of it should have jumped back because he's a blood spatter expert. And he wants to tell you that when you splash somebody in the pool, that when you do the water like this, I'm not getting hit with water. Speaking of water, before I even get there, the criminalist who examined this pipe told you that there's one end of the pipe that doesn't have blood. You can get a look at it. We'll send some gloves back, pick it up, hold it, examine it. There's not blood all the way up this pipe and then just 2 void marks on the pipe with no blood where these hands were at. There's no blood coming up the pipe. The blood is all focused on the end. If you showed me that the entire pipe was bloody and the only parts that weren't bloody is where somebody's hands would be, then we could have that expectation that someone's hands should be covered in blood. But there's no blood up at the top of that pipe. And whether that has to do with the trajectory or the force or the angle in which he swung, there's no blood up there. You can't have, it's just not there. No running water in that outbuilding. But Lon told you that when Luke was in the house after he killed these 4 people, that he wanted something to drink. Watch that surveillance again when he comes out of that house with a glass of water. Now, you want to talk about theories and hypotheses and possibilities. If you can go get a glass of water, you can go wash your hands. And moments after that murder, while Larry's being criticized for smoking a cigarette, Luke's in the front yard chugging a beverage. To say that Luke was traumatized, that he was dumbfounded and in shock, and to make Larry the monster because he smoked a cigarette. Because when he gets pulled away from the boat, which he's parked now, to follow his son to the shed to find out what Luke did, and is confronted with what he believed at the time to be 3 bodies, because he didn't see a man over in the corner. He told Lon 3 people up there dead. Is one Brent? Yeah. In running down to the house and telling Lon to call an ambulance now, call 911, call an ambulance, calling his son an idiot and flailing his arms and all of the above, that his trauma doesn't warrant a cigarette, but Luke's the traumatized one. Don't look at this case piecemeal, ladies and gentlemen. You have to, the same way you have to read the instructions all together, because no one instruction includes all of the law. No one piece of evidence proves this case. But all of the evidence together has met that burden, has been proven beyond a reasonable doubt. In voir dire, I talked to you about puzzle pieces. And if pieces were missing from the puzzle. I think I talked about a fin and a portion of the tail. Could you still see the killer whale in the middle of that picture? Without a surveillance video inside that shed, there's always going to be some pieces missing, even as much as who got killed first. Will gets killed first, Amanda runs and gets wedged, Brent and Kiana come in to check it out. Brent goes over to check on Roe, gets hit in the back of the head. Kiana then gets finished off because she screams. We don't know. That's my theory. You can theorize. But there's always going to be some pieces missing. Those pieces missing, though, do not equate to reasonable doubt. The killer whale is still present, and the killer in this courtroom is Luke Truesdell. He killed those 4 people. There is no evidence to the contrary. And all of the evidence, when taken in its totality, give you no other reasonable explanation for what happened that day. And so I stand before you and ask to thoughtfully review that evidence, determine from that evidence what is facts, and find Luke Truesdell guilty of all 4 murders in this case: the murder of Ramondis Cooper, the murder of Amanda Parker, the murder of Brent Brown, and the murder of Kiana Ryan. Thank you.
Thank you, Ms. Slaughter. At this time, I'll read the remaining logistical instructions. We'll start with instruction 43. During the trial, you've been allowed to take notes. You may take those with you into the jury room to use in your deliberations. Remember, those are notes and not evidence. Generally, they reflect a recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, you can leave the notes in the jury room and they will be destroyed. You may not communicate about this case before reaching your verdict. That includes cell phones and electronic media such as text messages, Facebook, LinkedIn, YouTube, Twitter, X, email, etc. Do not do any research or make any investigation about this case on your own. Do not visit or view any place that was discussed in this case, and do not use Internet Maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Do not do any research on information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the Internet to research events or people who are referenced in the trial. The case will be tried on the evidence which was presented in the courtroom. If you conduct independent research, you're relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that's been introduced here in court. If you do research or investigation or experiments that we don't know about, your verdict could be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and cross-examination. All the parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide the case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of this state, and you will have done an injustice. It is important that you abide by these rules. Failure to follow these rules could result in the case having to be retried and could result in you being held in contempt and punished. It is important that we have your full and undivided attention during the trial. Exhibits have been admitted into evidence and are to be considered along with all the other evidence to assist you in reaching your verdict. You are not to tamper with the exhibits or their contents, and each exhibit should be returned into open court along with your verdict in the same condition as it was when it was received by you. When you begin your deliberations, you should select a foreperson. They will see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express their views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement, if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During the deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it's the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are the judges of the facts. Your sole duty is to find the truth and do justice. Verdict forms have been prepared for you and are attached to these instructions. Your foreperson will sign the appropriate verdict forms which accord with your findings. When you have agreed upon a verdict for each count and the foreperson has signed the verdict form, you will notify the court attendant. So I will go ahead and sign these jury instructions and date them November 13th, 2025. All right, any additional record on the jury instructions from the state?
No, Your Honor.
All right, anything from the defense?
No, Your Honor.
All right, at this time we will be selecting our alternate jurors. So we're going to pull a name, and what we're going to do is thank and excuse 2 alternate jurors at this time. We're not going to release you from your admonition in case that you need to be called back at a later time, but we will call you with a verdict and release you from the admonition at that time. So, both set. You will be checking one only. Either the defendant is not guilty, guilty of murder in the first degree, guilty of murder in the second degree, guilty of voluntary manslaughter, or guilty of involuntary manslaughter. So those are the options that are available to you on each form of verdict. There are 4 total for each count represented, and there's going to be a space for you to sign and date for the foreperson on each of the 4 counts of verdict. That you were read. We will be calling you and letting you know when you are released from those admonitions. All right. Are you ready for the oath? So now I'll be giving the oath to the judicial assistant. Do you swear or affirm that you will take charge of this jury, keep them together in some private and convenient place, that you will not permit any person to communicate with them, and that you will return the jury into court when they have reached their verdict?
I do.
All right, members of the jury, it is now time for you to retire and deliberate on your verdict. The alternate jurors can also follow Alyssa. She'll direct you where to leave, and she will be providing you with your notepads that you use to take notes when you deliberate. Anything I'm missing? Okay, thank you. P10, I've got a P17. Am I missing any exhibits that were admitted?
No, Your Honor, we did not try to offer or admit any of the exhibits between 10 and 17.
All right, so then P1 through P10 and P17, are any of those necessary at a heightened security level in your opinion?
I would say they could be at the same security level as the state's.
All right, and did the state make any decisions on that, or do we want to take that up later?
We didn't make any decisions. I don't generally give any input on height security levels. I know there's rules the court follow for certain things, like autopsy pictures, and I just asked it. I'm not asking for anything more than is required.
Okay. Any further record either party would like to make at this time on behalf of the state?
No.
On behalf of the defendant, Mr. McCullough?
No, Your Honor, thank you.
All right, thank you. Please make sure that you provide Alyssa with a contact number where you can be reached, and we'll be adjourned until we have further information. Thank you.
office number or something, Steve? Thank you. Are you feeling?
Huh?
Are you feeling better?
Yeah.
Getting there?
I'm getting there. Yeah.
No, audio. Okay.
Broadcasting our conversation. Well, I'd like to see the.
I was upstairs and I'm like,
Would you stop or would you yell through your hole? Jesus Christ, man. Oh, no.
So 4 Dodge Dodgers. All right. How old are you? Oh. Yeah. You fucking babies. Holy cow. So, 1 out, 2 out, 3 out? 1 out? Okay. No, because she's going to say, like, oh, they're
42.
Yes.
56 and 52.
Adrian, I want you to know this is not actually directed towards you. That was to you, young lady.
Alright, I gotta go upstairs and take care of
Okay.
my. I got to talk to Sarah. She's not here.
Can you just find out what happened with Caston and Justin? He's not here. He's in federal custody.
Well,
I
I
don't
know.
care. I'm just curious.
Was that, is it just the E?
Yeah. Like a tax stamp and
Alright.
felon possession, I think.
Gotcha.
So, the general defense was there's not enough evidence, as I understand it, to get to beyond the shadow of a doubt. Last week when I was here, that was when you had the Thursday, the blood scatter. Yeah, the like kind of investigator. Like kind of like a lord thing. So you brought it over like he had his clothes and there was like his face on it, or a little bit on the shoes. I think the state showed that. And then you guys followed up with at the scene, huge things in blood spatter. I think I heard today that you've been brought in a blood spatter ambulance. They did.
No, she accused me of not being a blood spatter.
Okay, right.
Didn't accuse me. Didn't say it.
Okay, so I guess my question with that is, and making sure I was following. So the idea was big splatters at the scene, nothing on him. How does that match up? But you never like said it,
No, I said that.
did you?
Yeah.
Okay.
They just didn't bring an expert to say.
Yeah. My big point was, how is there no blood on board?
I might have missed that piece.
If you missed it, then stop talking until you get it. I'm so sorry. Okay.
No, you
I fuck with concerns. I am known for it. Please don't take offense to
No,
it.
I don't.
It is a joy of my life. That is why she put her hands in her head, in her hands, and he laughed and got off the table.
Okay.
That is a personal joy of mine. Please don't be offended.
I'm not.
Welcome to the office. What was Sasquatch's name? Doesn't matter. We had an attorney a couple of years ago, or a year or so ago. In Berkeley. And he was well, he had a beard. So I called him, I nicknamed him Sasquatch. Never to his face. I didn't like it. Anyway, but he said something to me down in 3C, where we do CNCs, you know? And my response was, I know what it was